Another possible defense is intoxication. We have to determine when we consider intoxication whether someone became intoxicated voluntarily or involuntarily. The difference being involuntary intoxication is when someone slips something into your drink. Think of The Hangover, when Alan keeps slipping roofies and other drugs into the guy's drinks, and then they go off on the weekend and have no idea what they're doing. This would be involuntary intoxication. So if someone slipped something into your drink and you didn't know that it was in there and you became intoxicated and you went out and did some criminal acts, you could claim involuntary intoxication, and that would be a complete defense. You could be found not guilty. However, voluntary intoxication is not a complete defense. If you get drunk yourself and you go out and commit crimes, that's not a defense to any criminal prosecution. However, it may help you a little bit, so it may be an incomplete defense because it may mitigate the mens rea. What we mean by this is, if you were drunk, then we may say that you didn't act purposely, you acted negligently because of your intoxication. So maybe instead of being guilty of a murder, you could be guilty of a lesser charge. Maybe we'd say instead of negligent, we'd say you were reckless. So instead of, you went out and you killed someone, and it would appear that you acted purposely, but you might be able to convince the jury that because you were intoxicated, even though you were voluntarily intoxicated, you got drunk yourself, that maybe you should only be considered to have acted recklessly. And so this would be manslaughter, still a very serious offense. You're still going to do serious time, but the jury may be willing to reduce your crime down from murder to manslaughter because of you were drunk at the time, and we say, we don't really believe you were truly acting purposely. You were acting recklessly instead. So voluntary intoxication may mitigate the charges against you, but it will not be a complete defense. Consent sometimes can be a defense. It depends on the crime. So if it's a sexual crime and the alleged victim consented, and it was truly a voluntary consent, it wasn't a forced consent, but if the victim consented to having sex, then you're not going to be guilty of rape or any other sexual assault, unless of course it's something like having sex with a minor. That's a different story, because the law concludes that a minor cannot consent at a certain age to sex. But absent that, if the person consented, then you could claim that as a defense. Similarly, if you punched someone, but you said the person told you, punch me in the arm as hard as you can, I can take it, then you couldn't be charged with an assault. Now, if you did it out in the public streets and it created a disturbance, then maybe you could be charged with some kind of disorderly conduct. But as far as the assault, if the person said, hit me, I want you to hit me, then that person has consented and you can't be charged with assault. It's why we don't charge boxers who are in a licensed fight with assault against each other, because both have consented to punch each other in the fight. So consent can be a defense. It can't be a defense to murder. So if a person says kill me, maybe they're suffering from depression, they're suffering from some physical ailment in which that causes them a lot of pain, and they just want to be put out of their misery, so they're asking you, please kill me. In any of these situations, consent would not be a defense to murder. You could still be charged with murder if you kill that person. Doesn't matter that they asked you to kill them. So consent can be a defense to most other crimes, but not to murder. Now, the exception to that is if you live in a state, and there are only a few of them in the United States. Washington and Oregon were the first, but a couple others have joined the club since then. But the great majority of states, including Pennsylvania, do not recognize euthanasia. But if you're in a state that does legalize euthanasia, assisted suicide, then consent is a defense as long as that euthanasia complies with the law. So it typically requires a somewhat involved procedure. So, for instance, in Washington and Oregon that have euthanasia laws, the person who wants to be euthanized has to have their medical condition reviewed by doctors. The doctors have to verify that this is a terminal illness, that the person will die from this illness within a few months, and then the euthanasia has to be carried out by doctors. So there are strict rules regulating euthanasia. So again, the situation where someone who isn't a doctor helps another person to commit suicide and plays an active role can still be charged. The fact that the person wishing to die asked them to help and basically consented to the killing is not a defense. So euthanasia is only a defense when it's carried out under the law of a state that has legalized it. So in that situation, the consent, the agreement to be euthanized, is part of the law and is a defense to any charges against the doctors. Condonation, which is forgiveness by the victim, is usually not a defense. It doesn't matter that the victim, after the act has been done, says, well, I forgive you. That's great. You know, they may win points in heaven for that. But as far as in a court of law, that typically is not going to be recognized as a defense. The state can still charge the offender with the crime and prosecute them. As you've seen with the Canvas materials, some jurisdictions do recognize syndrome defenses. So these are defenses that don't fit neatly under any of the previous defenses that we mentioned, the established ones like self-defense or insanity or any of these others that we've covered, but are maybe a new kind of defense. And so occasionally the courts will recognize them. I had you consider the battered person syndrome defense. Again, this is someone who's been abused for a substantial amount of time, and in a time when no abuse is currently occurring, maybe while their assailant is asleep, they kill that person. And so self-defense, as we've already mentioned, does not apply because there's not an immediate threat. However, some courts have recognized, upon hearing from psychologists and psychiatrists, that if you are chronically abused, you believe that you are under a constant threat. You believe that at any time this abuser can hurt you again, maybe even kill you, even when they're sleeping, that they pose a threat to you. And so most courts have rejected this defense, but some have actually accepted it, and the person has been found not guilty. There are other kinds of syndromes. There's the Twinkie defense. The person, Dan White, who killed Harvey Milk in San Francisco, who argued that he had been eating so much junk food that it caused an impairment in his judgment, and he was able to win on that defense. It was more substantial than just claiming that, but it was known popularly as the Twinkie defense. So again, we may see different kinds of syndromes that are recognized. We also recognize more and more that there are stress disorder defenses, and particularly PTSD, post-traumatic stress disorder. So the more we learn about PTSD, the more courts are accepting it as a kind of defense, that the person acted under this impairment. They weren't insane, as we've defined insanity, but they were impaired in some way that we think perhaps they shouldn't be held responsible.